Be ready for the dictation. Start. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court of Judicature for Rajasthan at Jaipur, by which the High Court has partly allowed the said appeal, and while maintaining the conviction of respondent herein for the offence under Section 307 IPC, has reduced the sentence from 3 years rigorous imprisonment to the period already undergone by him in confinement, and so far as the accused Mohan Lal is concerned, the High Court has not interfered with the order of the trial court convicting him under Section 324 IPC and releasing him on probation under Section 360 Criminal Procedure Code. The state has preferred the present appeal, that the respondents herein and others were tried by the learned trial court for the offences under Sections 147, 148 and 323 IPC, and also under Section 307 IPC. Respondent herein Banwari Lal was tried for the offence under Section 307 IPC for having caused grievous injuries on the skull of the head of the injured person. On appreciation of evidence, the learned trial court held that the prosecution has proved beyond reasonable doubt that the injuries suffered by the injured, which were caused by the accused, were sufficient for causing death in the ordinary course of nature. By observing so, the learned trial court convicted the respondent for the offence under Section 307 IPC and sentenced him to undergo 3 years rigorous imprisonment. However, so far as the accused is concerned, the learned trial court though convicted him but granted the benefit of probation. Feeling aggrieved and dissatisfied with the judgment and order of conviction and sentence passed by the learned trial court, the respondents preferred an appeal before the High Court. Before the High Court, the main submissions were made on behalf of the accused Banwari Lal, in which the respondents did not challenge their conviction but prayed to reduce the sentence so far as the accused Banwari Lal is concerned, on the grounds that occurrence took place about 26 years ago, that they were facing trial since last 26 years, and when the occurrence took place they were young and now they are old persons. It was also submitted on behalf of the accused Banwari Lal that as the benefit of probation has been given to the accused Mohan Lal, he may also be given the benefit of probation. Thereafter, without assigning any further reasons whatsoever and without considering the nature or gravity of offence and the serious injuries caused by the accused Banwari Lal on the injured, the High Court has partly allowed the said appeal, and while maintaining the conviction has reduced the sentence to the period already undergone by him. The High Court has dismissed the appeal in respect of the accused Mohan Lal. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court interfering with the sentence imposed by the learned trial court and reducing it to the period already undergone from 3 years rigorous imprisonment imposed by the learned trial court insofar as accused Banwari Lal is concerned, as also confirming the order of probation insofar as accused Mohan Lal is concerned, the state has preferred the present appeal. There is a huge delay of 180 days in preferring the appeal, and therefore a separate criminal miscellaneous application is filed by the state, praying to condone the delay. Learned advocate appearing on behalf of the state has vehemently submitted that in the facts and circumstances of the case, the impugned judgment and order passed by the High Court reducing the sentence to the period already undergone from 3 years. Rigorous imprisonment imposed by the learned trial court is unsustainable. It is vehemently submitted that as such there are no specific reasons assigned by the High Court while reducing the sentence imposed by the trial court. It is contended that while reducing the sentence the High Court has not at all dealt with and or considered the mitigating and aggravating circumstances, which are relevant for the purpose of imposing an appropriate punishment. It is submitted that the High Court has not at all considered the gravity of the offence and the serious injuries sustained by the injured Phul Chand. It is further submitted that when the judicial discretion was exercised by the learned trial court sentencing the accused to undergo 3 years rigorous imprisonment for the offence under Section 307 IPC, the same ought not to have been interfered with by the High Court, more particularly when the appeal challenging the conviction was not pressed. It is prayed to allow the present appeal, quash and set aside the impugned judgment and order passed by the High Court and restore the judgment of the learned trial court. The present appeal is vehemently opposed by learned advocate appearing on behalf of the respondents. Learned counsel appearing on behalf of the accused has vehemently submitted that there is a huge delay of 180 days in preferring the appeal against the impugned judgment and order passed by the High Court. That the accused have resettled in their lives and their conduct has since been satisfactory, and after the impugned judgment is passed, they have not indulged in any criminal activity and the occurrence is of the year 1989. To revive the proceedings would be extremely harsh and unjustified. Therefore, it is prayed not to condone the huge delay of 1880 days in preferring the appeal. On merits, learned counsel appearing on behalf of the accused has vehemently submitted that while reducing the sentence the High Court has considered the submissions on behalf of the accused Banwari Lal that the occurrence took place about 26 years ago and that the accused were facing trial since last 26 years, and that when the occurrence took place in the year 1989 the accused were young and now they are aged persons. It is submitted that the aforesaid can be said to be relevant considerations while reducing the sentence to the period already undergone. Learned counsel appearing on behalf of the accused has further submitted that insofar as granting the benefit of probation to the accused Mohan Lal is concerned, the same was granted by the learned trial court, against which the state did not prefer any appeal before the High Court. It is therefore submitted that when the High Court by the impugned judgment and order has dismissed the appeal preferred by the accused Mohan Lal, it is not open for the state to now challenge the order granting benefit of probation to the accused Mohan Lal when the same was not challenged by the state before the High Court. Making the above submissions, it is prayed to reject the application for condonation of delay as well as the appeal even on merits. We have heard learned counsel for the respective parties at length. At the outset, it is required to be noted that the accused Banwari Lal was convicted by the Learned Trial Court for the offence under Section 307 IPC for having caused serious injuries on the vital part of the body of the victim Phool Chand.